Issue number 5 is whether the lower court was not in error in striking out several paragraphs of the petition and the replies of the appellants on the ground of vagueness and lack of specificity, and for being new issues, mere denials, or being repeats. Well, this issue relates to the ruling of the court below on the first respondent's preliminary objection, seeking an order of court striking out 31 paragraphs of the petition on the ground that they were very generic, imprecise, lacking in to elicit reply from it, and contrary to paragraph 4.1 of the first schedule to the Electoral Act 2022. The court, after scrutinizing each of those paragraphs in a well-considered ruling, struck out 10 paragraphs, namely 92, 95, 98, 121, 126, 129, 133, 143, 144, and 146, precise and lacking in particulars. For the purpose of clarity, the court held on page 8025 to 8026 of the record as follows. The sum total of all the foregoing is that while paragraph 129 and 133 of the petition are liable to be struck out for non-joinder of necessary parties, to which Masters Adejo and Governor Yahya Bello of Kogi State, accused in the petition of committing electoral malpractices, paragraph 92, 95, 98, 121, 126, 129, 133, 143, 144, and 146 are vague, imprecise, and lack of particulars, and so fall short of the requirements of paragraph 4.1b of the first schedule to the Electoral Act 2022. They are therefore all other struck out. Paragraphs 93, 94, 96, 97, 99, 100, 101, 102, 104, 105, 108, 109, 110, 111, 112, 113, 14, 115, 116, 118, 119, 120, 122, 125, 130, 134, 138, 139, 140, 141, 42, 145, on the other hand, are in order and properly pleaded. End of quote. Picked by the above ruling, the appellate striking out their replies to the respondents' replies to the petition. For instance, as touching on the disqualification of the second respondent from contesting election for the office of president, which were supplied in the appellant's reply. It is instructive to note that in paragraph 146 of the petition, the appellants simply averred that, quote, the second respondent was at the time of the election not qualified to contest the election, not having the constitutional threshold, end of quote. They did not supply the particulars of the threshold, which they perceived disqualified the second respondent from contesting the election, as enumerated in section 137 of the Constitution of the Federal Republic of Nigeria, 1999, as amended. Howbeit, in their reply, the appellant ruled out monstrous particulars of disqualification by reason of dual citizenship, allegation of being an ex-convict in the U.S. District Court, having forfeited to the USA the sum of $460,000 in a drug-related case, Note that these particulars referred to as further details were brought in by their appellants at the time when the respondents had lost their right of reply, which in essence offends the cardinal principle of fair hearing expressed in the Latin maxim audi alteram partem, meaning let the other side be heard as well. Paragraph 4.1 of the first schedule to the Electoral Act 2022 provides that an election petition shall A. specify the parties interested in the petition, in the election petition, B. Specify the right of the petitioner to present the election petition. 3. State the holding of the election, the scores of the candidates, and the person returned as the winner of the election. And 4. State clearly the facts of the petition and the grounds on which the petition is based and the relief sought by the petitioner. It is clear beyond a peradventure that the requirement of the law is as provided above is that the petition must demonstrate with specificity the complaints of the petitioner and the relief sought from the court. It gives no room for vagueness and imprecision. This is in line with the rule of pleading, that where an averment is not supported by evidence, the averment is deemed abandoned. For, in keeping with the audi alteram patem rule, to prevent surprise or ambush on the defendant, it is the plaintiff's claim that will enable him to file his defense. See when the West Africa Limited and Econife citation supplied, Akonde and Adisa and another citation supplied, PDP and INEC citation supplied. It follows, therefore, that a petition must be detailed and comprehensive on material facts depending on the relief sought, and not evasive or vague, so as to elicit a response from the respondents. Indeed, by the provision of paragraph 16, sub 1A of the first schedule to the Electoral Act 2022, the Act frowns at the introduction of new facts, grounds, or prayers tending to amend or add to the averments of the petition in the petitioner's reply. In fact, a petitioner is only required to file a reply in answer to new issues or facts which may be raised in the respondent's reply, which were not dealt with in the petition. This means that where there are no new issues of fact raised in the respondent's reply, there would be no need for the petitioner's reply. See Oni and Lebanji citation supplied. I have critically considered the arguments of parties contained in their respective briefs of argument vis-a-vis the record of appeal. The affected paragraphs of the petition relates to allegations of wrongful cancellation of polling unit results in various local governments in Sokoto State without particulars, manipulation of results in unspecified polling units in some local government areas of Kogi State, wrong results entered for the appellants in unspecified polling units in Borno State, criminal allegations against qualification against the second respondent, and tying critical allegations of corrupt practices in the election to a statistician report prepared by one Samuel Odutan, that's PW21, without serving the same report on the respondents along with the petition to enable them to respond thereto. I am unable to agree with the appellant's argument that the lower court was wrong to have struck out the affected paragraphs for disclosing no particulars, together with some replies in the appellant's reply brief, which sought to bring in new evidence through the back door. I uphold the decision of the lower court, striking out the affected paragraphs and replies to the appellants for being vague, imprecise, lacking in particulars, and seeking to ambush the respondent by the petitioner's replies. The ruling of the lower court is unassailable, and this court will not interfere. This issue again is resolved against the petitioners.
As the court places.
Issue 6 is whether the lower court was not in error in its evaluation of the evidence of the appellant witnesses on the burden of proof and clear admission against interest made by the first respondent. This issue turns on the averment of the first respondent in paragraph 8 of his reply to the appellant's petition, that the appellants in this case won the contested election in 21 states out of the 36 states of the Federation, namely Adamawa, Akwa Ibom, Bauchi, Bayelsa, Borno, Delta, Ekiti, Gombe, Jigawa, Kaduna, Katsina, Kebbi, Kogi, Kwara, Nasarawa, Niger, Osun, Sokoto, Taraba, Yobe, and Zamfara states. The appellants contend that such affirmation is tantamount to admission against interest by the first respondent. They therefore question the declarations to return of the second respondent as the winner of the said election. On his part, the first respondent contended that its said admission is of no consequence, having regard to the fact that the appellant scored 6,984,520 votes, as against the second respondent who scored 8,794,726 votes. That in determining the winner or loser in an election to the office of president, the number of states won by a candidate merit any consideration except in the context and requirements. In its evaluation of evidence on the issue, the court below on page 8238 of the record had this to say, quote, the table referred to by the petitioners is the table of results declared by the first respondent. There is no other set of results placed before this court by the petitioners to form the basis of our finding of fact as to whether the declared result is wrong or not. Success or failure in an election depends on figures, which is in turn dependent on votes garnered by each candidate. So, where the complaint in an election petition is that the candidate returned did not poll majority of the highest votes in the election to as contended here by petitioners. Not only must the figures disputed be pleaded, the figures of votes the petitioner perceives as figures of the election ought to and must be pleaded. The court went further to hold on page 2854 of the record that, quote, Section 134 sub 2 of the 1999 Constitution talks of the highest number of votes cast at the election if the contest was among more than two candidates, as in the instant case, not majority of votes cast as propounded by the petitioners. The first respondent was therefore right from the result declared by her in the absence of any rival or alternative results placed before this court by the petitioners. That the second respondent, who scored 8,794,726 votes, as against 6,984,520 votes scored by the petitioner, the issue of electronic transmission of results, which is the main thrust of the appellant's contention in this appeal. I shall not revisit the point under this issue. On the condition that the first respondent's affirmation that the appellant won 21 states out of 86 states of the Federation, thus constituting an admission against interest, the position of the law is well settled, having regard to who can be declared winner of a presidential election in Nigeria. Section 184 sub 2 of the 1999 Constitution makes it explicit that, quote, a candidate for an election to the office of president shall be deemed to have been duly elected where there being more than two candidates of the election. A, he has the highest number of votes cast at the election, and B, of at least two-thirds of all the states in the Federation and the Federal Capital Territory, Abuja. End of quote. In this appeal, the issue before us is not who among the candidates won in the majority of the states of the Federation, which is debatable, but who scored the highest number of votes at the election. I have strenuously combed through the respective briefs of the parties vis-a-vis the record of appeal, I am unable to find any alternative figure put forward by the appellant as their rightful votes scored in the election, other than the scores presented by the first respondent, INEC, showing that the second respondent scored the highest number of votes. It is presumed correct. In the case of Abubakar and Yaradua, citation supplied, this court held that, and I quote, election results are presumed by law to be correct until the contrary is proved. It is, however, a rebuttable presumption. In other words, there is a rebuttable presumption that the result of any election declared by a returning officer is correct and authentic, and the burden is on the person who denies the correctness and authenticity of the return to rebut the presumption, end of quote. See also CPC and INEC, Buhari and Obasanjo, Hashidu and Goje, all citations supplied. Following from the above, it is clear that the appellants, having not put forward their perceived rightful score to rebut the result put forward by the INEC, the law presumes the first respondent's version as correct. It would not matter whether the appellant can prove having won most or if the first respondent admits that much. The figures before us shows that the second respondent won the highest number of votes and was accordingly returned elected. From whence, therefore, would we manufacture evidence to support the appellant's claim that they scored the majority of lawful cast at the election, or that there was non-compliance with the Electoral Act which affected the credibility of the election? Nowhere. Definitely not from the evidence on the record. And that is why this issue is resolved against the appellants. Finally, let me say a few words concerning issue number 7, which is whether the lower court was right in its use of disparaging words against the appellant in its judgment, evincing hostility and bias against the appellants, thereby violating the right to fair hearing and occasioning great miscarriage of justice. I have read the judgment of the court below, and I've seen the context which those words were used, and it is my view that they were not meant to disparage the appellants or their counsel. As judges, we are trained to be templates in our use of words, and we shall continue to do so. Litigants are advised to trust the court whenever their matters are before it. It is very unbecoming these days that while a matter is pending in court, litigants engage in press conferences, analyzing the case, reaching conclusions. Based on this, some of their followers send threatening messages to judges and justices. Matters in court are said to be sub judice, and as such, parties and probably their counsel should refrain from media trial. Has nothing positive to offer the appellants. On the whole, having resolved all the issues against the appellants, it is my view that there is no merit in this appeal, and it is hereby dismissed. The judgment of the court below, delivered on the 6th of September 2023, affirming the election of the second respondent as the duly elected President of the Federal Republic of Nigeria, is hereby affirmed. I shall make no order as to costs. My learned brother on my right will deliver his judgment.
Well, my lords, learned senior counsel and all other counsel, this time around it will not be a 12-hour judgment. So, my Lord, Honorable Justice Okoro has said it all, but we must agree. So, having had a preview of the judgment of my learned brother, John Ian Okoro, JSC, availed me with a copy of the said judgment just delivered in SC/CV/935/3 Atiku Abubakar and the Independent National Electoral Commission and others. I completely agree with the critical analysis of both the oral and documentary evidence presented before us in this appeal. Therefore, I agree with my learned brother that the motion of the appellants filed on the 6th of October 2023 for leave to the appellants to adduce fresh or additional evidence is devoid of any merit. I also dismiss the same. On the main appeal, my learned brother resolved all the issues, the 7 issues against the appellant. I therefore agree with him that the issues in the main appeal are devoid of merit, and the appeal is accordingly dismissed. And I also did not make any order as to cause, but affirm the judgment of the lower court, declaring the second respondent, Bola Ahmed Tinubu, as the duly elected President of the Federal Republic of Nigeria in the election of the 25th of February 2023. Thank you.
My learned brother to my immediate left will deliver his judgment.
The lead judgment just delivered by my learned brother Okoro JSC has comprehensively presented all the points I made and the views I expressed at the conference of the Honorable Justices of the panel over the appeal. He has very proficiently presented all the views which I express in respect of all the issue in both the motion for leave to adduce or produce fresh or additional evidence, as well as the first respondent's motion to strike out some grounds, and the main appeal itself. But I would like to say that the point raised by the learned senior counsel for the appellant, Chief Chris Uche Ezean, particularly in respect of the application of Section 285(6) of the Constitution, along with the relevant provisions of the Constitution, as well as the Electoral Act 2022, is with respect to Chief Uche Ezean spacious. As demonstrated in the lead judgment, the provisions of Section 285(6), even if the Court of Appeal is not specifically mentioned in that section, the provisions of Section 285(6) is applicable and apply to all proceedings in respect of all petitions, whether before tribunals or the Court of Appeal sitting as a court of first instance trying a petition named presidential election petition. for which it was conferred or vested with the original exclusive jurisdiction to entertain under Section 239 1A of the Constitution. So I completely agree. This is an interesting point, like I said, because this is the first time it is coming up, and it is good that this court will make a firm pronouncement in order to avoid further or few arguments in respect of this particular issue. In addition, the issue of a candidate scoring 1/4 of votes in the FCT has also been settled by this court before now. And it is that the lead judgment had affirmed that the FCT is not elevated to a higher pedestal than any of the states of the Federation. It is, for the purposes of the presidential election, one of the states for which a candidate is required to obtain at least 1/4 of the votes in 2/3 of each of the states. So I totally agree with the lead judgment that this court lacks the requisite jurisdiction to entertain the application for leave to produce fresh or additional evidence, and that this appeal is also lacking in merit and deserves to be dismissed. I also dismiss the appeal, and that will be my judgment in this appeal. I abide by the consequential orders made in the lead judgment on cost to be borne by the parties for the prosecution of this appeal.
My learned brother, Salawa, will deliver his judgment.
My learned brother, the Honorable Justice Okoro Jesse, has accorded me the opportunity of a preview of the judgment that he has just delivered. I must say that I have read that judgment, and I'm very much content erudite reasoning and conclusion that have so far been reached in the lead judgment. I concur with the highest sense of responsibility of the reasoning and conclusion which there, with particular regard to the interlocutory application, thereby urging upon this court to grant leave to the appellants to procure and transmit I concur most assiduously with the conclusion that has been reached in the judgment of my learned brother that such an application is grossly meritorious, that's got to be dismissed, and same is accordingly hereby dismissed. And as for the substantive appeal, which has been predicated on a total of 7 issues. I agree entirely with the reasoning evidently expressed by my learned brother that each of the 7 issues that have been canvassed and argued by the appellant are grossly unmeritorious, thus ought to be resolved against them. Without much ado, I hereby accordingly dismiss the appeal for being grossly unmeritorious. As usual, it is not the time for us to read elaborative judgments. Just like my learned brother said, 12 hours. We're not going to do that because learned counsel representing the respective parties in this appeal will have every opportunity to be served with the complete judgments of each and every justice of this panel in due course. Because constitutionally, we have a total of 7 days within which judgments must be served on the respective learned counsel of the appeal. Thank you very much.
My Lord Jaro, read your judgment.
Okay. Well, I've had the privilege of reading before now the lead judgment delivered by my learned brother, John Ian Okoro, JSC. His Lordship has ably considered and resolved all the issues in contention in the appeal, as well as the application. I agree with the reasoning and conclusion reached therein to the effect that the appeal is bereft of merit and deserves a dismissal. The application too is not meritorious. Accordingly, I dismiss the application and the appeal. That is my position.
My Lord Abubakar.
I thank my Lord the Presiding Justice, Honorable Justice John Ian Okoro, for granting me the privilege to read in draft the lucid and illuminating leading judgment just delivered in this appeal. I start with the application. The application seeking to adduce additional evidence or fresh evidence, I also find it lacking in merit. The application is frivolous and vexatious. It deserves to be dismissed, and it is hereby dismissed.
Those complices.
Now, coming to the substantive appeal, I find no merit in the substantive appeal. It is all and the judgment of the lower court is affirmed. Parties in this appeal shall bear their respective costs.
Those complices.
Yes, Iroko. Agim, JSC.
Those complices.
With the kind permission of the learned presiding justice, let me also express my view. I had a preview of the judgment delivered by my learned brother, Lord Justice John Iyan Okoro, JSC CFR. With commendable erudition. Let me, however, say maybe 1 or 2 things since we will have opportunity, you will have opportunity to have our views, that the deposition is, for this additional reason, inadmissible. So if a document is inadmissible, you cannot ask that you should be allowed to bring it in as fresh evidence. A reading of the deposition exposes that it is not authenticated by the seal of the authority before whom it was issued. A deposition from another country to be used in Nigeria should prima facie bear features of authentication, such as the official seal of the court, where it is sworn, if it is the court, or if it is before a notary public, his seal or signature, or if sworn before a person legally authorized to take the seal, or if sworn in the Nigerian Embassy, High Commission, consulate in that country, the signature of the officer authorized to do so, and the seal of the Embassy, High Commission, or consulate. Such authentication is an assurance of the origin and authenticity of the foreign disposition. In our present case, the certified shorthand reporter, before whom the disposition was made, did not authenticate the disposition with that seal. He merely signed a certificate of reporter bearing a name and number, page 126 of Exhibit C. Being a disposition from another country, cannot be used in Nigeria without authentication. The authentication of the oath administration is mandatory. I've wondered why the deposition said to be made pursuant to the 3rd of October 2023 order of the United States District Court for the Northern District of Illinois in case number 23 CV 05099 for use in a foreign country was not made before the court in the said proceedings, and if made elsewhere in the law office of the first appellant's attorney, why was it not filed in the above mentioned court? Because of the circumstances of this case, and adopted as a deposition ordered by that to be made by the court, so that it can form part of the record of that court to enable the court issue it as part of its record, and so authenticate it with the seal of the court and the signature of the relevant officers of the court. Page 1 of the deposition is headed in the United States District Court for the Northern District of Illinois in reapplication of Atiku for an order directing discovery from Chicago State University, post 1 to 28 U.S.C. 1782, number 28 CV 05099. This gives the impression it is a process of the district court, or that the deposition, though made outside the presence of that court, private law office is part of the proceedings in case number 23 CV 05099, if it is indeed a process of the said district court, or forms part of the proceedings in case number 23 CV 05099 before it, then it ought to have been authenticated by the official seal of the court and the signature of the relevant officer certifying it as a true copy of the part of the record of the court in case number 23 CV 05099. Without such authentication, a deposition cannot be used in the Nigerian court as part of the proceedings or in the state U.S. District Court. And I've continued to wonder why the college, why the appellant did not use the advantage of the order of the district court that the college produced documents and a deposition concerning those certificates. Why they didn't use that advantage to secure a letter from the college under its letterhead, seal, and signature, disclaiming the certificate presented by the second respondent to INEC as not one issued by the college. That was not done. Instead, they resorted to this deposition, which has no features of authentication, thereby rendering it spurious and inadmissible. I agree with the able manner the lead judgment has dealt with it. I agree totally with all the reasons given in that decision as to why such an application should be refused. And it emphasizes one point. It was obvious to all, including those who brought it, that it was going nowhere. Then the question is, why was it brought? And I agree with my Lord when he described it as a vexatious process. I dismiss the application too. I go to the appeal. I agree completely with the lead judgment. I cannot say it better than that. It was a real brilliant expose on all the issues raised. Let me also join my Lord Garba to talk about a question of Abuja and 1/4 of the votes there. Candidate must win. They view that the provision of the Constitution should be applied in such a way that the votes in Abuja must be won. 1/4 of the votes must be won by a candidate before he can secure victory in the election. To me, violates a fundamental principle of constitutional interpretation, that it must be interpreted to protect the spirit of the Constitution. And if you look at our Constitution, so it must be applied in such a way as to protect the equality of the votes in all the entities, and not otherwise. I will expand on that in my judgment. So I do not agree with the interpretation placed upon it. Attractive as it may be, but we must bear in mind that there's no jurisdiction in the world where a constitution is read in isolated patches and given meaning that should have, very narrow meaning that should appeal to certain sentiments. No, you apply it as a whole, reading it completely together, so that you rely on one part to get a meaning in another part that the words can truly support the wordings used in that provision. That is how to read a constitution. Remembering that it is dealing with a dynamic system, a human society. For these reasons, I also dismiss the appeal. I also agree that the parties should bear their costs. Thank you very much.
Thank you, my lord. We are now left with the next appeal. I call the next one.
SCV 937-2023, Mr. Peter Gregory Obi, Labour Party, Appellants, Independent National Electoral Commission, INEC, Senator Bola Ahmed Tinubu, Senator Shetima Kashim, All Progressives Congress, APC respondents.
Appearances.
The Lordship, my name is PIN Ikweto. My Lords, unfortunately, we have a type list of counsel, and by the time my colleagues brought it to the registry, they were told it was late. If Your Lordship will allow me, can I submit that list?
Please, sir, submit it.
Thank you, my Lord, sir. And my Lords, with respect...
Judgment day, you don't go late to court.
I was here before, I was here by 8 o'clock, sir.
So that you won't be late when God will be giving judgment.
Oh, my Lord, on the day of my own judgment before the Lord, I will be there alone. So I'll be late there.
So,
and I'm sure He will accept me when I get there, sir.
God will accept you.
I'm sure He will.
I pray it should be so.
Amen, sir. My Lord, I want to say that my name is PIN Ikwetu, and Your Lordship, with respect, we have, in line with Your Lordship...
I think we should start calling you Saint Ikwetu.
My Lord, I cannot be while still on earth. Yes, sir.
Until you die.
While still on earth, I cannot be. I'm a sinner.
Let's find a place and discuss that.
Your Lordship, please. My Lord, Your Lordship know where we can discuss that, sir. My Lord, we've taken the liberty to tick the names of my colleagues who are with me.
Azinge.
Number 3, Dr. Mrs. Valerie Janet Azinge, SN. Number 4, my Lords, Alex Ejesieme, SAN.
Azinge.
Yes, sir. Azinge is number 3, sir.
Yes.
Number 4, my Lord, is Alex Ejesieme, SAN.
Where is Azinge?
My Lord, Azinge is just beside me here. She's been here all morning with me.
Azinge used to be black. I don't know why she's white today.
No, she's always been fair complexion. Always. Yes, sir. The husband is dark complexion.
Okay, it's the husband that is dark.
As a Lordship, please. Yes, sir. But she's been fair complexion all along.
It's okay. You're welcome.
Yes, my Lord, sir.
Leonard SN Ikweto, did you say Valerie is number 3?
My Lord, on the list, she's number 3.
But she's number 2.
She's number 2, yes, sir. Yes, sir. I just want to make it easier for my Lord, sir. The next, my Lord, is Mr. Alex Ejesieme, SAN.
Yes. Chike.
My Lord, there's a Chike AOB Esquire.
Yes.
And my Lord, lastly, and in compliance with my Lord's directives, Ejiofor Onwaso Esquire. Your Lordship, the appearance with due respect is for the appellant in this appeal.
Yes.
Please, my lords. I am Sir Stephen Adehi. I am number 2 on the list.
Where is your list?
We submitted a list this morning, my lord.
Stephen
Adehi, my lord. Sir Stephen Adehi.
Leave that thing. Adehi.
Yes, my lord.
Yes.
I appear with my learned friends of the inner bar.
Yes, yes.
Al Hassan A. Umar, SAN, is number 4 on the list.
Umar.
Yes, my lord.
Yes.
And number 7 is Wendy Kuku, Esquire, my lord.
Yes. Yes.
Number 8, Jamiu Aguru, Esquire.
Where is Jamiu Aguru?
And finally, number 10, Z.U. Obansa, Esquire. Our appearance, my lord, is for the first respondent. May my lords be pleased.
Is that for the... Yes?
Sorry, my lord. My attention has just been drawn.
tell those guys this. Tell them that this thing can amount to contempt of court, so they should be careful.
As copies.
My Lord, the last person on our list, my Lord, is actually number 9, Amira Hamisu, not Obansa. Number 9, Hamisu Esquire. Yes, my Lord. Not number 10, my Lord. Thank you very much, my Lord.
One, two, three. Amira. Hamisu. Yes.
If it pleases my noble lords, my name is Akintola Makinde, and I appear with my colleague, Okpe Muritala. Your Lordships, we submitted the typewritten list in the morning. Very respectfully, our appearance is for the second and third respondents. We are very grateful, sir. Okpe Muritala, my lord, is number 2 on the list here.
Yes.
We are very grateful, sir.
Yes.
With profound respect to my lordships.
Yes.
Olumide Olujimi. My lord, my appearance is for the 4th respondent.
Yes.
Appearing with me, I'm learned friends. My lord, I'm sorry the next name is not on the printed list which we submitted.
Let me, okay, yeah.
Professor Abdul Karim Kana. And Abdul Wahab Abayomi. We all respectfully appear for the 4th respondent. I'm much obliged, my lord.
For the 4th respondent.
Respectfully, my lord.
Well, in this appeal, we have, during conference, noticed that issues number 1, 2, 3, 5, 6, and 7 in this appeal in S6 to CB, so 501 to 2023, which judgment was delivered on the 26th of May 2023, this court cannot allow the matter to be relitigated in this very court. There must be an end to litigation. For us to sit down now and talk about when this man resigned or did not resign, when they did a fresh conference or fresh primaries to replace him, which we have done before. We are not going to do it again. This matter ought not to have come here. When the matter was pending at the trial court, this court delivered by judgment. You read the judgment of the lower court, they mentioned it, that Supreme Court this appeal lacks merit and is thereby dismissed. My lord, to my right. Abaji.
I agree with my learned brother, Justice John Ian Okoro, that this appeal, number SCCB 937 2023, is a Peter Gregory Obi and the Independent National Electoral Commission lacks merit, and it is also dismissed by me.
My Lord Garbages.
I also totally agree with the judgment that this appeal substantially canvass the same issues with the appeal number 935/2023, which this court has very comprehensively dealt with, and there's no need for us to repeat ourselves because the issues are the same. The only issue that's different, like pointed out by Alana brother, the PJ, is that about double nomination, which you have settled, and we do not intend to open it again in this appeal. On the whole, I also join the judgment to dismiss this appeal for lacking any merit.
My Lord,
having had the privilege for now of reading and draft the judgment prepared and delivered by my late brother Okoro JC, I cannot but concur with the reaching and the conclusion that has been postulated in the judgment to the fact that the instant appeal lacks merit, that ought to be dismissed by this court. I have associated myself with such reasoning and the conclusion. I have no hesitation whatsoever in dismissing the appeal. Appeal dismissed.
my Lord Jauro.
I had the advantage of reading in draft copy of the lead judgment just delivered by my learned brother, John Ian Okoro JSC. I entirely agree with the reasoning and conclusion contained therein that the appeal is void of merit and it ought to be dismissed. Consequently, I join my brother in dismissing the appeal.
My Lord Abubakar Jesse.
I also had the advantage of reading in draft the judgment of my learned brother Ian Okoro, the C, and I'm of the view that the appellants have nothing useful to urge this court. The appeal lacks merit, and it is hereby dismissed by me.
My Lord Akim Jesse.
I had a preview of the judgment delivered by my learned brother, Lord Justice John Ian Okoro. I completely agree that this appeal lacks merit.
Thank you all for listening. The two appeals, I think we have concluded our job today. remains is for us to go and rest. Thank you very much. We shall rest.
All right, so we're live from the Supreme Court in Abuja, where breaking news is that the Supreme Court has affirmed President Bola Tinubu as Nigeria's president. Now, this is following the dismissal of the Supreme Court of the appeal by former Vice President and presidential candidate of the People's Democratic Party, Atiku Abubakar, seeking to nullify the February 25 presidential election of President Bola Tinubu. Now, in a unanimous judgment, the Apex Court dismissed Atiku's appeal for lacking merit, and such affirmed the judgment of the Presidential Election Petition Court, which affirmed the election of President Tinubu.
Now, in the notice of appeal, Atiku had urged the Apex Court to dismiss and set aside the September 6 judgment of the Presidential Election Petition